Section 11 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Elsie Selwyn. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 5. The Weregelds of the Burgundian and Wisigothic Laws. Subsection 1. The Burgundian Weregelds. It is not proposed to do more in this chapter than very briefly to examine the laws of the Burgundians and Visigoths with reference to the evidence they contain with regard to the results of contact with Roman and Christian civilization upon the solidarity of the kindred, as shown in the payment of weregelds. The remoteness of these tribes from any connection with the Anglo-Saxon invasion of Britain makes it unnecessary to do more than this. Indeed, this chapter might have been omitted, but for the useful light it may throw upon the process of disintegration in tribal custom in the case of tribes settling in countries with a long-established civilization superior to their own. In such cases, tribal custom, however hardly it might resist, had eventually to succumb, thus affording a strong contrast with the Cymric and Irish examples, in which tribal custom was so much better able to hold its own, and even succeeded to some extent in forcing tribal rules upon the new Christian institutions. The Burgundian laws, so far as they belong to those first issued by Gundobald himself, fall between AD 501 and 516, and his reference to his ancestors in his preface shows that, while he may have remodeled the laws to meet altered circumstances, they were in part based upon traditional customs of his people. But his people were in a new position. Geographically, they were sharing with a population still under Roman law the southwestern part of the Helvetian Valley, i.e. between Neuchâtel and Geneva, and a good part of the old country of the Sequani on the Gallic side of the Jura. They seem to have come into this district not altogether as conquerors, but in some sense as invited guests. According to Title 54 of the laws, the newcomers, by the munificence of the Burgundian king and his ancestors, had delegated to them individually in a particular place hospitalitas, which constituted of 2/3 of the land and 1/3 of the slaves of the hospice upon whom they were quartered, and by this clause in the laws they were forbidden to take more. It is generally understood that this method more or less closely resembled the Roman method of quartering soldiers upon a district. The Burgundians, therefore, came into a district with a mixed population of Romanized Gauls and Germans, already, after long residence and many vicissitudes, living and settled under Roman law, and regarded by the newcomers as Romans. Thus 2 sets of laws became necessary, one for the Burgundian immigrants, the other for the old inhabitants who were to continue under Roman law. Now, under the Roman law there was no weregeld, and so in the Title II of the Burgundian Lex Romana, the slayer, whether a freeman or slave, if captured outside a church, was condemned to death. If the homicide was in defense of life, it was to be referred to judicial decision according to the novellae of Theodosius and Valentinian. If the slayer had taken refuge in a church, quia de preciis occasionem nihil evidenter lex Romana constituit, the Burgundian lawgiver decreed that if a freeman by a freeman should be killed, and the slayer should flee to a church, he who confessed the homicide should be adjudged to be the slave of the heirs of the person killed, with half of his property, the other half to be left to the heirs of the slayer. After this follows a clause, also of Burgundian origin, fixing the payment by a freeman who has killed a servus and fled to a church. The price is to be paid to the lord of the servus on the following scale: for an actor, 100 solidi; for a ministerialis, 60 solidi; for a plowman or swineherd or shepherd or other servi, 30 solidi; for a goldsmith, 100 solidi; for an ironsmith, 50 solidi; for a carpenter, 40 solidi. This by order of the king. Now, if from these clauses of the Lex Romana which relate to the Roman population, we turn to the Title II of the Burgundian law proper of Gundobald de Homicidis, we may gather what the old customary wereguilds may have been, but at the same time recognize how strongly Roman law and ecclesiastical influence had led Gundobald to break through what to the Romanized conscience seemed to be the worst features of the system of tribal wereguilds. From Title II De Homicidiis, it appears that the original wereguilds were these: Optimatis nobilis 300 solidi, aliquis in populo mediocris 200 solidi, minor persona 150 solidi, pretium serdui 30 solidi. These wereguilds closely correspond with those of the Alemannic and Bavarian laws, but the first clause enacts that the homicide of a freeman by another, of whatsoever nation, shall only be compounded for by the slayer's blood, thus overriding tribal usage and introducing the Roman law. The second clause enacts that if the homicide be in self-defense against violence, half the above-mentioned wereguilds should be payable to the parentes of the slain. Clause 3 enacts that if a slave, unknown to his master, shall slay a freeman, the slave shall be delivered up to death and the master free from liability. Clause 4 adds that if the master was privy to the crime of his slave, both should be delivered to death. Clause 5 enacts that if the slave after the deed shall have disappeared, his master shall pay 30 solidi, the price of the slave, to the parentes of the slain. And lastly, in Clause 6, the parentes of the slain are in all these cases warned that no one is to be answerable for the crime but the homicide himself, because as we enact that the guilty shall be extirpated, so we cannot allow the innocent to suffer wrong. The new law breaks away altogether from old tribal traditions, and an attempt is made to treat homicide from the new point of view of reason and justice as between one individual and another, with but little, if any, regard to kindred. From the law against theft, we get a scale for the equation of cattle, etc., with gold. If a Burgundian or Roman ingenuus steals away a slave, horse, mare, ox, or cow, he is to lose his life, unless he takes refuge in a church. And from the property of the criminal, the price of the stolen animal is, in simplum, to be paid to the person robbed, unless the thing stolen can be found and restored, i.e., for the slave, 25 solidi, for best horse, 10 solidi, for moderate horse, 5 solidi, for mare, 3 solidi, for ox, 2 solidi, for cow, 1 solidus. Thus, from these traditional values, retained even under new circumstances by the Burgundian law, we learn that the weregeld of the middle class of freemen, mediocres in populo, of 200 solidi, was still regarded as the equivalent of 100 oxen or 200 cows. There is no doubt in this case that the solidi were those of the imperial standard. The Burgundian kingdom was destroyed by the Franks in AD 534, i.e. before the issue by Merovingian princes of solidi and trientes of the Merovingian standard. Subsection 2. The weregelds of the Lex Wisigothorum. The laws of the Visigoths are too Roman to be taken as evidence of what may have been the ancient tribal weregelds of the Goths. Their rule extended to the Loire till they were driven back to the Garonne by the Franks in the 6th century, and lasted in Spain and Aquitaine to 711, when it succumbed to Arab conquest. The Visigoths conquered a country already under Roman law, with a mixed population of German as well as Celtic and Iberian tribes. They were not the first German intruders. They were invaders, but not altogether at enmity with the Romans. Their princes, after the breakup of the Roman power, issued gold coins, solidi and tremisses, in close imitation of those of the Eastern Empire. Goth and Roman were encouraged to marry on equal terms. And though there are traces of a scale of payments and composition for homicide, it bears little trace of the tribal principle of the solidarity of the kindred. There is no scale of payments directly under the head of homicide, and we are left to gather incidentally what the weregeld, if it can be so called, may have been. In a clause added between 653 and 672, it was enacted that upon the kidnapping of the child, son or daughter, of a free man or woman, the criminal was to be delivered over into the power of the child's father or mother, brother or nearest parentes, so that they may have power to kill him or sell him. And if they desired it, they might demand the composition for homicide from the criminal, i.e. 500 solidi, some MSS 300 solidi, the crime being to the parents no less grave than homicide. If the child could be recovered, half the composition for homicide was to be paid, and if the criminal could not pay, he was to become their slave. This doubtful mention of 500 solidi or 300 solidi finds some explanation in a later clause. Indirectly, again, we get the scale in force for homicides in 58 Title 4 S 161 of about the same date. It enacted that injuries done by vicious animals known to be such were to be paid for sicut est de homicidis by the constituted composition compositio constituta, and then the following scale is given. Aliquis honestis 500 solidi, ingenuus persona 20 years old and up to 50 300 solidi, ingenuus persona from 50 to 60 200 solidi, older than this 100 solidi, youths of 15 years 150 solidi, youths of 14 years 140 solidi, youths of 13 years 130 solidi, youths of 12 years 120 solidi, youths of 11 years 110 solidi, youths of 10 years 100 solidi, youths of 7 to 9 years 90 solidi, youths of 4 to 6 years 80 solidi, youths of 2 to 3 years 70 solidi, youths of 1 year 60 solidi, daughter or wife from 15 to 40 250 solidi, daughter or wife from 40 to 60 200 solidi, daughter or wife older 100 solidi. Under 15, half the payment for a male, liberty half payments. It is impossible to look upon the scale as fully representing ancient Gothic tribal tradition, and when we turn to the title Decada et Morte Hominum, which seems to belong to the same date, it becomes obvious how far the spirit of these laws had wandered away from any tribal standpoint and from all recognition of the solidarity of the kindred. A homicide committed unknowingly, nesciens, is declared to be in the sight of God no cause of death. Let the man who has committed it depart secure. Every man who killed another intentionally and not by accident was to be punished for homicide. The punishment had, in fact, already been a matter of criminal law. The prosecution for homicide was no longer to be left only to the parentes of the slain, quote, for they might be lukewarm, end quote, S. 15. The judex ought to take the matter up, and on neglect of his duty was to be liable for half the payment for homicide, viz. 250 solidi. Strangers in blood as well as relations had already been enabled to bring the accusation. Chindas Vinth, who reigned from 642 to 653, had legislated in the same direction. The question had arisen, what was to be done with homicides who took refuge in a church and committed themselves to the protection of God? Seeing that everyone ought to be punished for his crime, he issued an edict to settle this question once and for all. He enacted that whatever slayer or evildoer the law required to be punished, no power whatever should be able to shield from punishment. And although the criminal might flee to the sacred altar, and in that case no prosecutor could drag him away without the concurrence of the priest, yet the priest, having been consulted, the sacrament having been given, was to repel the criminal from the altar and expel him from the choir, so that his prosecutor might apprehend him. The criminal thus expelled was to be freed from any further death penalty, but short of this was to be in the power of the parentes of the slain, who might do what they liked with him, i.e. he became their slave unless presumably the composition required was paid. The successor of this king, 653 to 672, dealt with another point in which tribal instinct was at variance with Roman law. With the dissolution of the kindred disappeared the reason and traditional justification for the rule that there was no feud and no weregeld within the kindred. Tribal custom everywhere left the worst crime of all, murder of a parent or a kinsman, without redress, at the same time unpardonable and unavenged. It became, therefore, needful to promulgate an edict that the judex should punish the murder of a kinsman by death. And, in this case, if there were no children, all the murderer's property was to go to the heirs and near relations of the murdered person. But if there were children of another marriage, innocent of their parents' crime, half only of the property was to go to the children of the murdered kinsman, and half to the innocent children of the parricide. If the murderer had fled to the altar of a church, he was to be delivered up to the parentes or propinqui of the slain kinsman to be dealt with as they chose, short of death, and if there were no such parentes, his property was to go to the fisc. The murderer whose life was thus spared was not to have the use of the property. Lastly, there was found in some of the MSS, as an addition to Libris 12, Title 2, an edict of King Wamba, who reigned 672 to 680, which seems to mark the last stage in the process of confining the punishment of the crime to the criminal alone. Up to this time, as we have seen, the murderer, with all his possessions, was by law to remain the slave of the parentes, or the next heirs of the murdered person, except in the one case of the murderer having children by another wife. Thenceforth, if the murderer, according to the edict, had children or wife free from participation in the crime, he alone was to be delivered up to the parentes or next heirs of the dead. His possessions were not to go to them, but to the children or heirs of the criminal, on the ground that the punishment should in justice fall alone upon the sinner and not upon his innocent family. Clearly, the last tie of tribal instinct securing the solidarity of kindreds was now broken. It had lost its ancient significance. Murder had become the crime of an individual against the state, and a matter of criminal law. The only survival of tribal feeling seems to have been that, as some compensation to the family of the murdered man, the murderer whose life the church had saved was to become their slave. End of chapter 5. End of section 11.